My name is Dr. Ron Lewis. I'm Chair of Panel A of the Medical Board of California. This is an open session for the Medical Board, and once we dispense with the formalities of establishing a quorum, etc., we'll go into closed session, which means 99.9% of you will have to exit until we go back into open session again. It's on. Do you want me to repeat all that again? Please don't say that. Okay, so let's, first order of business, and then we'll introduce ourselves for the court reporter who's asked to, for us to state her name and any unusual spelling so she can copy that down. So we will now establish a quorum. So Diane, are you calling the roll? Okay, Diane will call the roll.
Dr. Hawkins?
Here.
Mr. Warmoth?
Here.
Ms. Wright? Here. Dr. Yip?
Here.
Ms. Sutton-Wills? Dr. Lewis?
Present.
We have a quorum.
Thank you. Okay, it looks like we'll go into closed session, correct? That's pretty easy. So enjoy the nice weather. And those of you who need to stay for the closed session will stay. The rest of you will have to, we're doing the oral argument first, yes. So after the oral argument, we'll go into closed session. Sorry about that, the weather's too nice. It's So let's have the everybody introduce themselves, please, starting with my left.
David Warmoth.
Ron Lewis.
Jamie Wright.
Felix Yip.
Randy Hawkins.
And I'm ALJ Adam Berg.
Okay, get all that? Good. Thank you very much. So we'll go into oral argument of non-adopted proposed decision on Dr. Durrani. So, and then I will now turn this over to the ALJ.
Okay, thank you. Parties want to come on up? Yeah, I'll call the case first. All right, this is, as noted, Panel A of the Medical Board of California, hearing oral arguments in the matter of Quorum Khan Durrani, MD. It's case number 800-2016-021897. Today's date is October 17, 2018. Hearing being held in San Diego. Again, my name is Administrative Law Judge Adam Berg. I'm with the state's Office of Administrative Hearings. I am presiding over the hearing today, but I am not a decision maker in this matter. If the parties would enter your appearances, please.
Greg Chambers, Deputy Attorney General of the State of California, representing the Medical Board for the purpose of this matter.
Ivan Weinberg on behalf of Dr. Quorum Durrani, who is to my left.
All right. These are oral arguments on a non-adopted proposed decision by the administrative law judge. Both parties will have 15 minutes to make their opening arguments and a 5-minute rebuttal. Mr. Weinberg, do you want to reserve any time for your client to address the board directly?
Not necessarily.
Okay. I will give you then maybe a wave my hand at 3 minutes and then a 1-minute motion if you need that long. Is that sufficient for you?
At 8 and 1, did you say?
Whatever you would like. How about that?
Yeah, I suppose 8 would be good and 1 would be good too.
8 and 1. Okay.
Yes, may I ask a
will.
question before we begin?
Certainly.
I've noticed that there were some issues about a quorum here this afternoon, and I'm wondering
There was a
whether there are
quorum.
people that are missing, and whether or not those people who are missing would participate in the discussion and vote in the closed session.
There is a quorum, and no, they will not be participating if they are not present at this
Thank you very much.
moment. All right, let me get my fancy stopwatch on. All right, Mr. Weinberg, it's all yours.
Thank you. First, I want to thank the panel for being here today and giving us an opportunity to speak to you. It's an important situation, and I think that it deserves all of our very close attention. Let me begin by saying that this is not a case of sexual misconduct. It's been mischaracterized as that, I think, by the Deputy Attorney General. Rather, it is about the exercise of clinical judgment in doing two limited, focused examinations that consumed several seconds each. Dr. Durrani has no history of any formal complaint of any kind in 25 years of practice. He's quadruple boarded as a psychiatrist, well-trained. The standard of care that was utilized throughout this case was the APA guidelines, which were introduced by the medical board in this case. And the APA says that physical examinations, even sexually sensitive exams, are within the clinical judgment of the psychiatrist. The American Psychiatric Association Principles of Medical Ethics were what was introduced. And just to orient us, paragraph N.1.H reads as follows. Question, is it ethical for the psychiatrist to perform full physical examinations, including vaginal examinations on female patients, either in the office or in the hospital? Answer, a physical examination by a psychiatrist is not in and of itself unethical. Physical examination should be performed with the usual safeguards to avoid any exploitation of the patient. It is also essential. It is also essential that the psychiatrist not practice outside of his or her professional competence. So the board has claimed that these two examinations conducted by Dr. Durrani were inappropriate because they were sexually sensitive, but that's not the standard here. And we think that their experts just have it wrong. Dr. Durrani brought two very distinguished and qualified psychiatrists to testify consistent with the APA guidelines, and said both of the exams were appropriate and that he had correctly exercised his clinical judgment. So reasonable persons have differed on this, and Dr. Durrani fully understands that the board's obligation here is to protect the public, and he's perfectly willing to accept the board's view and any reasonable restrictions that they may deem appropriate in this case. I want to say, though, that the DAG has adopted what I consider a very questionable, if not ridiculous, position. For example, one of the statements in the written submission is, quote, the evidence in this matter overwhelmingly established that respondent fondled his patient's genitals, then lied to cover his tracks. That is preposterous. Dr. Durrani was not charged with any sexual misconduct in this accusation. None was found by the ALJ. There's no evidence of sexual misconduct. None of the experts say there was, and in fact, the expert testimony was that there was no evidence of any sexual motivation in this case. And I just have to say that I think that kind of hyperbole is a disservice to this board. I think it's a distraction to you folks who are charged with making a decision in this case, and I think it discredits anything that this DAJ may recommend with respect to a disposition here. I don't think it's worthy of the Attorney General's office. I think the idea of Dr. Durrani's lying is absurd. Dr. Nzinga Harrison, the medical director of ANCA, we'll get to that in a moment, the person who was most critical of Dr. Durrani during these examinations, supported his truthfulness. She testified, quote, I don't feel like he distorted the details of what he told me. So it's all a parsing of words. If it's about whether Dr. Durrani used a glove or a Kleenex, any doctor would avoid skin-to-skin contact in an examination of a patient. So there's no difference of substance here. It's like whether you paid a parking ticket by credit card or by cash. The fact is that you paid. So the point is that it comes down to whether Dr. Durrani exercised his clinical judgment appropriately when he did these two focused examinations. In doing them, he believed that he was helping these patients with important presenting issues. He exercised his judgment in favor of doing the examinations, and it wasn't a failure to recognize a medical issue. It wasn't a question of medical competence. It is a matter of judgment. So at most, it's our statement that this should lend itself to some educational remediation to satisfy the board that we're all on the same page as to how Dr. Durrani's judgment should have been exercised. While that's happening, if the board remains concerned about Dr. Durrani's safety, there might be a chaperone present for physical examinations and some monitoring to ensure that that would be done, but education that would satisfy us all as to what exactly the proper judgment was in this case. Now, I know you've all read the materials, but just a couple of key points to underline. First, the residential facility where this occurred was Casa Phoenix, short-term residential facility, mostly for mental health and addicted patients between the acute facility and home, with an average stay there of 7 to 10 days. Dr. Durrani was not engaged in any kind of psychotherapy. His job was to do examinations for entering patients. That was what he was contracted to do, and in the course of those physical examinations, he would take vital signs, would address whatever medication issues presented physical issues, and would also address focused physical exams if anything came up relative to their presenting problems in the course of the broader examination. He was the only licensed physician there. In fact, he was the only licensed provider, medical provider, so he had to do the exams. They were not full diagnostic examinations, but really only focused examinations to see if the patient should be returned to Kaiser for detailed assessments and treatment. Now, what about these two examinations? There are two patients, LW and DL. LW's exam was very brief. He came to Casa Phoenix from the Kaiser emergency room where he was seen for a wound on his left toe. He presented to Dr. Durrani barefoot with dirty feet, trailing a bloody bandage on his left toe that was coming loose, walking with a limp, and he appeared flushed. Dr. Durrani was immediately concerned about the potential of an infection that could deteriorate during his stay at Casa Phoenix. He undertook one of these focused examinations we were talking about to determine if the patient should be sent back to Kaiser for treatment. He examined the foot, he checked the leg for streaking, then he took a couple of seconds to palpate the left inguinal area through the clothing for possible swollen inguinal lymph nodes. Finding none, and no other concerning signs, he so noted the chart. LW never made any kind of a complaint, and in fact, when asked about the exam, he said it was unremarkable. The other patient was DL, also very brief. He asked Dr. Durrani to check if there was a testicular cancer on a lump that he had found. His complaint, which is the primary basis of this accusation, was made only after Dr. Durrani refused to provide him stronger medication that he requested, and he was an addict. In the course of taking his history, Dr. Durrani was educating DL about the implications of drugs that he was taking, and he mentioned various risks of chronic cannabis use, including testicular cancer. The patient was immediately alarmed, said he had a lump on his testicle and had had it for some time. Dr. Durrani inquired whether he knew how to conduct self-examinations. DL said no. He dropped his pants and asked Dr. Durrani to check it and was very anxious. Using either a glove or a Kleenex to avoid skin-to-skin contact, Dr. Durrani did a 2 to 3 second check and determined that the lesion was not on the testicle but on the scrotal skin, was likely a sebaceous cyst. He reassured DL of that fact and said that he should be seen by his primary care physician soon, and DL was, needless to say, very relieved. The DAG, in his written submission, has totally misrepresented the facts of this encounter. He has said that DL made his complaint the very next day, on March 26th. In fact, that's not true. There was no complaint at the exam. The patient asked to see Durrani again the next day afterwards, and clearly didn't have much of a complaint if he wanted to come back and see him. Dr. Durrani could not see him that day, but fit him in the following day. They had a meeting at which DL requested increase in pain medications and in medications for sleep, and Dr. Durrani refused because he was an addict, and he became angry And it was the following day, the day after that, 3 days after the initial examination, that the complaint was made. Now, the board experts did not fully agree with one another on the basis for the claim here. Dr. Harrison agreed that a psychiatrist doing testicular examinations is not always a departure from the standard of care, but she said that no physical examination of any kind should be conducted in this residential setting. The APA guidelines clearly say that it is a matter of clinical judgment for the psychiatrist. We read that earlier. Dr. Chuang, the other expert for the board, testified that the APA had, quote, an explicit prohibition against sexual contact, unquote, concluding that a psychiatrist should never do sexually sensitive physical examinations as it impaired the psychotherapeutic relationship. He was wrong about that, demonstrate his failure to understand the APA guidelines, which clearly say that it is that sexual examinations, such as vaginal examinations, can be done by psychiatrists if they are done at appropriate times in an appropriate setting. And he also didn't understand that Dr. Durrani did not do psychotherapy on patients in this setting. Respondents' experts were very distinguished, and they agreed with one another with respect to their opinions that there was no unprofessional conduct here. One was Dr. John Rosenberg, a distinguished psychiatrist, well-educated, a prior chief of staff at Alta Bates Hospital. He said, in my opinion, his examination was important to address and respond to the patient's sudden expressed concern to assess him for a potentially significant medical problem. The only apparent alternative would have been for Dr. Durrani to refuse to perform any exam on an agitated patient with what was established to be an actual physical complaint, and instead refer him out for what would likely have been a traumatic but ultimately unnecessary ER visit, contrary to his treatment needs and program. I find nothing outside the standard of care, and certainly nothing about this interaction which would constitute an extreme departure given the context. Further, given the nature of his role for ANCA, I likewise do not believe there was a failure to maintain appropriate professional boundaries under the circumstances. The other respondent expert was Dr. Mark Block, also a distinguished psychiatrist, who said, it's my further opinion that such exams did not violate any professional boundaries, given the context of the visit and his role with the patients, which was not, as a therapist, providing active or ongoing mental health treatment. While I do not disagree with Dr. Chuang's comments about sexual relationships with patients being forbidden, there is nothing in the materials to suggest anything sexual about the encounters with DL or LW, both of which exams Dr. Durrani charted. However, I disagree with him that the standard of care is generally to, quote, strive to avoid physical contact, unquote, with patients, as there's no such absolute prohibition. Further, when a patient has an acute medical issue, there's no prescription against a psychiatrist as a licensed California physician performing an exam, particularly in this setting and given Dr. Durrani's role. Just to revisit briefly the recommendations, discussion about what might be appropriate here in terms of a disposition. As we've said, it's important to get something that will satisfy the board, but at the same time allow Dr. Durrani to continue the good work he is doing as the medical director of the Department of Behavioral Health in the county of San Joaquin. We said first the idea of possible education, a professional boundaries program, because this issue does arise out of a discussion about professional boundaries, so it would be good for all of us to understand and have insight into what the appropriate judgment was under these circumstances. A clinician-patient communication course might be appropriate, medical record
One minute.
record-keeping course, professionalism program, and if there is continuing concern about safety, perhaps chaperone and monitoring. It's envisioned that any order would be a public letter of reprimand with conditions. A soft admission would take cognizance of the viable dispute that we have here. Probation places Dr. Durrani at risk of possible exclusion from the Medi-Cal and Medicare programs, which are the principal funding sources for the medical services that he provides to the underserved and poverty communities in San Joaquin County. Just a word about revocation, because he did not admit any error. We cited cases in our submission that show that it's not legal to punish on that basis. So notwithstanding the Attorney General's mischaracterization of the case as sexual misconduct, it's a close question of medical judgment, and Dr. Durrani is perfectly willing to abide by whatever this board decides.
That's time.
Thank you very much.
All right, thank you. Mr. Chambers, would you like any cues for your time?
Chair, same as before.
All right,
Appreciate it.
I'll
Thank
do a hand wave at 8 and then a oral 1 minute.
Appreciate it, thank you.
All right, you may begin.
This matter is about trust and judgment. And the administrative law judge who heard the matter sat through the entire hearing, and at the end of the hearing, wrote a proposed decision. 16 pages. And on page 16, the administrative law judge called out the respondents, quote, lack of candor, close quote, and respondents, quote, dishonesty, close quote. Throughout the testimony and the records, there were mischaracterizations of what occurred with the patients at issue. Today we had mischaracterizations. It was claimed that nobody found sexual misconduct. That's not true. If you look at Zinga Harrison's report, page 16 of her report, I take it back, page 15. Quote, it is my professional opinion that Dr. Durrani's behavior represents sexual misconduct against these patients, close quote. But let's not stop there. Let's go to the written submission from respondent. I would direct you to page 8, where they state key facts establishing the context of this case. 1, says that Dr. Durrani's duties included the conduct of physical examinations. And then they give a page for you to cite, page 115 of the hearing transcript, lines 15 through 18. It was the testimony of Dr. Zinga Harrison. Zinga Harrison says, yes, they're supposed to do physical examinations, blood pressure, heart rate, temperature. Then if you look at lines 21 through 25, she says, quote, I was not aware that Dr. Durrani was doing genital examinations, close quote. Second point they raise on that same page, that patients who are admitted to an institutional setting uniformly have a physical mental examination. Casa Phoenix was not an institutional location. It was a step-down residential facility. The patients, LW and DL, both had Kaiser insurance, and they had received physical examinations at those institutions. Those two, 1 and 2, are both misleading. They're red herrings. They're not what happened. What happened was we have the most vulnerable people in society. In the case of DL, diagnosis bipolar 2, history of suicide, history of self-mutilation, history of substance abuse, homeless, and he defers, when he's at the Kaiser facility, a genital examination. So when he goes in to see Dr. Durrani has 4 different stories. That's where the candor and dishonesty come. That's why there's very serious concern. Many of the points that he raised at the subject interview and at the hearing were never in the records. Why not? That's troubling. What's equally troubling is that Zinga Harrison, when she finally did a report, an investigation, because nobody ever believes they're mentally ill, she found that there had been a third person that had complained about a genital examination by Dr. Durrani. But that person's complaint was never investigated because they believed the mental acuity of that person did not suffice or would not stand up to an investigation. They didn't believe him. For once, the vulnerable in the society were being believed. So let's go back to the mischaracterizations that have been presented by Dr. Durrani throughout this. Page 8, the written examination, the written Submission. The cost and inconvenience of transporting Casa Phoenix patient to an outside facility would have been substantial. That's not true. Dr. Harrison knocked that down in testimony. These patients all had Kaiser insurance. 4, circumstances where the DL had not had a physical examination for 2 to 3 years. He had just had a physical examination at Kaiser. He refused the genital examination. That's in the records. So we go to the next page, 5, regarding LW. The risk of spreading infection was plain. No, it wasn't. It wasn't in the records. It didn't come up until testimony. And it was all made up, and the ALJ saw through that. And that's why she called out the candor and the trustworthiness of this individual. And when she said that he should be revoked, it wasn't because he wouldn't admit to something. It was because he couldn't be trusted with the most vulnerable people in our society. But that's not enough for them. We go to page 9, line 20. Dr. Chuang, quote, Dr. Chuang opined there was an absolute ban on sexually sensitive physical examinations, close quote. And then they direct you to page 216, lines 7 through 18. Dr. Chuang never said that. He never said there was an absolute ban. He was questioned. He was asked if it was inappropriate to do an exam. It says, do you consider it inappropriate for Dr. Durrani to do a brief exam of the lump to evaluate whether it was something acute? Answer, yes. He then went on to describe that it's because physical examination of the area that has for many people sexual overtones, and in the particular context of a patient who had done commercial sex work, that is DL, who was an admitted male prostitute, this is something that I think poses some risk in terms of possible psychological harm to the individual. Now, Dr. Durrani claims to be the director of a county mental health facility in San Joaquin County where he supervises 30 people, and yet he doesn't believe or consider the psychological damage that his examination could do to a male prostitute who's bipolar with the history of that patient. That's outrageous. That's where we get to trustworthiness and truth and judgment. And that's what the ALJ who sat through this saw. We had arguments that were popping up all over the hearing in order to place blame on other people. Dr. Durrani claimed that he wasn't given timely access to medical records because he would not pass over his EMR funds to Casa Phoenix. Again, what type of a medical director who spends 40 hours a week at a county facility in San Joaquin County and moonlights 4 to 5 hours a week at another facility would put up with that? We're to believe that? I don't think so. But that's the type of stuff that was popping up in the hearing. The idea that this patient had sepsis and had to be checked for sepsis, when the patient, we're talking about LW, the patient had nothing in the medical chart to substantiate that. At the hearing, he said the patient was flush. That wasn't in the medical records. There were no striations. There was no notice about temperature. There was nothing in there to lead one to believe there was any problem with infection or sepsis. These were red herrings that were being thrown out all over the place, and it comes right to the judgment of this individual. There was a statement that Dr. Rosenberg claimed that the patient was suddenly agitated. Patient DL was suddenly agitated and therefore dropped his pants spontaneously. That was never put in the records. In fact, when Dr. Zinga Harrison had the first conversation with Dr. Durrani, I believe it was March 30th, he never mentioned that. The story kept moving. It was a moving target. Dr. Rosenberg and Dr. Block were not found to be persuasive by the ALJ because they were considering information that had been undercut previously in the hearing. Look at the record. The record's replete with issues of mischaracterization by the respondent. Everybody else can be attacked. That's certainly what Dr. Durrani did in the hearing. Everybody else was at fault, and that's what's happening today. But we had two patients that were both homeless and both mentally ill, and they were not treated right. The question is, who else wasn't treated right? Well, we know there was one other person that made a complaint, but LW never even complained because he didn't know what the standard of care was. He didn't know that was inappropriate. How many other mentally ill patients don't know that it's inappropriate? Thank you for your time.
Okay, thank you. Any questions from the panel members before we go to closing remarks? If you just state your name.
Dr. Hawkins, a question about the medical record. In general, do all the patients return with a medical record that you have the opportunity to review? So, for example, when your patient returned from Kaiser who had the wound on his foot, would he have returned with a medical record, what the emergency physician doctor found, and assessment and that sort of stuff? Similarly, the patient who had a physical done a couple weeks beforehand, would that been made available to you?
I can answer that. Dr. Hawkins, first of all, there are medical records that are in the Kaiser records that are in the computer, and a question came up about whether or not Dr. Durrani had access to those, and there was an issue about whether or not his incentive payments for the medical health, the electronic health records, had already been paid to the County of San Joaquin and therefore had not been paid. Council makes a lot out of that and says that there was misstatement about it. Actually, what Dr. Durrani said was he did not have a password. He did not have access to the computer. It may be because he didn't give over his, didn't assign his payments like all the rest of the staff did, but for some reason he was not a priority. As a consequence, what happened was the people downstairs, when he came in to do the examination, would put together a chart that stayed with the patient at the facility, and that chart had various aspects from the Kaiser record. And so he reviewed that chart. I would like to say, though, that insofar as the two issues that you are talking about, one is what happened with the patient that had the bloody foot at the ER, and the other was whether there was a physical examination with DL. I have to say that that would not have made any difference in either one of these, because insofar as LW was concerned, he had a bloody foot and a filthy leg and foot, and the bandage was coming off. Dr. Durrani was concerned about whether or not there might be some infection going on and what to do about that. So whether or not he'd been seen would not have affected looking at a bloody foot and wanting to be sure that there was no problem with further infection. As to this statement about DL and the record that he had had an examination earlier, that's all true. And that is in the record, that there was an examination and that it notes that genital examination was deferred by the patient. The point is that there had been no discussion about the effects of chronic cannabis use being a problem insofar as testicular cancer is concerned. That the patient had never known that until he had a conversation with Dr. Durrani about it, and he became alarmed about that and wanted to know if he had cancer. So he had a lump earlier. It was not examined, but he didn't have any reason or concern about having it examined until the discussion of cancer came up.
Dr. Hawkins, can I address your question?
Sure.
All medical records are provided to the facility in a referral packet before and at the moment that the patient arrives.
So a paper packet?
It's transmitted by fax and electronic. And so all those records are actually in the transcript, in the exhibits.
Okay.
Would you like to have Dr. Durrani explain how the medical record works?
Sure.
Dr. Hawkins. So what would happen, I would walk in and then I would ask the staff at the front desk to print out records for me. The printer would take 30 to 45 minutes to print out records. I would start assessing the patient. In the interim, when I'm assessing the patient, the records would come, and sometimes the system would not work, and I would have no records. Most of the time, I would get records. Now, meaningful use is the thing which my counsel was trying to explain. Meaningful use, you can give your money to one aspect of the society or organization. So I gave my money because county became electronic long before ANCA became electronic. So I had my meaningful use money given there. I requested the chief kindly convert me to electronic, and she says it's in the process. So I never had an access, electronic access at all. I would only request the front desk staff to print out things for me while I will start seeing the patients.
And actually, that testimony, that statement there was undercut by Nzinga Harrison at the hearing, that she had provided him password and access, and whether he utilized it, that was his decision, but that's not, that's a mischaracterization of what was testified to.
Council keeps using the term undercut, but Dr. Nzinga Harrison has an office in Atlanta. She doesn't spend much time out here and is not very familiar with how this whole situation works. And it wasn't,
All right, why don't we,
it wasn't undercut. There were two testimonies, one and the other.
all right, did that answer your question?
Yes, it does. I don't want to monopolize this time too much. Just have two other questions. One is with LW, did you consider asking him to remove his clothes so you could better examine the inguinal region rather than feeling it through his clothes?
Honorable member, I didn't. The reason was that I was doing triage, and I have done a lot of experience in that. So if it was more than 3 centimeters, and I would have been able to palpate, which are the standards that I follow, I would have requested at that time that probably it is infectious, and I would have requested at that stage that I'm sending you to urgent care. I was just doing a basic triage at that stage, just to identify as to where the acuteness of the situation is.
And my last question is that I'm an internist, and I exercise judgment in my evaluation and treatment of patients. And I just wonder, notwithstanding what your counsel stated, do you find any inherent problem with general examinations in individuals who are felt to be more vulnerable than others and misinterpreting what they may be experiencing?
I am very sensitive to my patients. If there is any history of sexual trauma or anything like that, I do not go that way. None of these patients, repeatedly in the records it says that the patient was sexually abused, and I have communicated that the patient is sexually abused. None of these patients were sexually abused. I'm very sensitive even in questioning. I tell my patients, if I ask you a question that you feel uncomfortable, you don't have to answer. But I have to get all the information in 90 to 120 minutes from birth to where the patient currently is. So I'm going at a rapid pace and asking questions. Thank you.
I would like to just add to that. This is a quadruple boarded psychiatrist who has been practicing for 25 years. He is Stanford and UCLA trained, and so obviously he has a great deal of concern about the vulnerability and about the mental status of his patients. I did want to say that I was a little bit concerned and unclear as to why we were not allowed to have the county, who is his employer, the County of San Joaquin, submit an amicus brief that addressed the very things that you're talking about here and what they think of him and how he came up through the ranks to be elevated to the director, medical director of behavioral health. So he certainly has a sensitivity for the kinds of things you're talking about.
Okay.
I respect your zealous representation of your client. I do, especially being a lawyer. However, a little bit of what I'm hearing from you almost sounds like this, and I could be totally wrong, and I'm hoping you address it, okay? It sounds like these folks are addicts, and they're poor, and they're liars. That's kind of how I heard it in some of what you said.
Oh.
So I would like for you to tell me obviously, if we rejected this, it could go one way or the other based on what you've come to us and said. Just speaking candidly, sometimes you have a lot of persuasion based on what comes before us. There's some discrepancy in the record on things that your client said. In his, one place I'm reading tissue paper, another place I'm reading a glove. Explain to me, notwithstanding the fact that these people are poor and addicts, why there's discrepancies in the record from what your client said between different times and the discrepancies in what the experts are saying. Stick to the kind of points as to why there's discrepancies and why your client didn't do any of this and why we shouldn't be revoking his license, because public protection is paramount for us, and reading something like this is troubling.
So I'm a little concerned, Ms. Wright, frankly, and a bit taken aback as to what it might have been that I said that had you thinking that for some reason I was trying to argue that it really didn't matter that these were mentally impaired and poor people, because I personally have a tremendous sensitivity about that and devote a good part of my life to just that population. So I'm unclear exactly where that came from. If you did have that sense from anything that I said, I want to hasten to say that Dr. Durrani went to work for the County of San Joaquin in the underserved population, in the poverty community, precisely because he wanted to work with the underserved community. He comes from a country where there are a number of underserved people and very poor people. He went to work with this particular organization, the ANCA Behavioral Health Organization, because it deals with the underserved community, and these are the patients that he cares about the most. So I don't mean by anything I say to either put the onus on the patient. I mean, I heard counsel saying that Dr. Durrani is blaming other people. He blames no one. He simply says that this is the work that I do, this is the job that I do, and he hears people saying, no, we aren't going to have psychiatrists doing physical examinations, particularly those that have any kind of sexual sensitivity to them. So what I mean to be saying is that is a judgment question, and don't take my word for it, that's what the APA says in its guidelines. And so what we have here is one party, the board, saying that he should not have exercised that judgment in favor of doing these examinations, and the other party, which is Dr. Durrani, saying here's what I was thinking when I did it, and this is what I think throughout. Now, let me just say that the notion that this is a genital examination, first of all, the examination of LW was of the pelvic area where the inguinal lymph nodes are, and that is not a genital, and it isn't next to a genital. And this was done through the clothing. Both of the examinations were for a matter of a couple of seconds. So he was confronted with circumstances that it seemed to make sense for the safety of this patient. I mean, when we talk about the potential of spreading infection, we're not talking about spreading it throughout the home, the residence. We're talking about it spreading with respect to this patient. If in fact this was as bad as it looked like it could be, then he should have sent this patient back to Kaiser for antibiotics, and that was what he was trying to find out. In the case of DL, he was confronted with somebody who was immediately alarmed and agitated and very concerned. As Dr. Rosenberg said, his option was to say, I'm not going to do anything. I want you to pull your pants up and we're going to send you somewhere else. That's what what Dr. Harrison and apparently the AG is saying he should have done. The experts for Dr. Durrani both have said that wouldn't have made any sense whatsoever until he had some determination that there was something here to be concerned about. And as it turned out, this was a superficial skin lesion and not anything that was of concern. So I hope I've answered that.
No, the way you just said that just now, that's what I wanted to hear. Just the way you came initially, and I can only say so much, just kind of gave me a little pause, but that's really what I wanted to hear, that this is a judgment call between this doctor and these experts, and there's a difference of professional opinion, which I can flow with that, but not like something that kind of has an undertone of these people are lying because they're poor and they're addicts.
Absolutely not.
Okay.
I think that they're saying exactly what they mean and what they think. By the way, so far as the
I don't
ALJ
know.
was concerned in coming to her conclusion, I think that what her point was, rather than there was anything sexualized on the part of Dr. Durrani, that he had intended anything sexual. I mean, counsel used the term fondling his patient's genitals, which is the part that I object to so much, because no one has said that. But I do think that her concern was, when you have patients like this who are possibly patients who might misinterpret something that you're doing, there is a mental issue, there is an addiction, then extra care has to be used. Now, I think Dr. Durrani does exercise that care and was exercising it in this context. What I'm proposing to the board, however, is something that, if you are not completely satisfied that that's the case, would resolve that.
All right, any other questions from?
Yes.
Well, I actually don't want to have him say something. We need to keep this in the controlled, so I'm gonna, no, I'm interrupting you, sorry. Okay,
Leave it there.
questions from the board, please.
Wait a minute, it's on, good. This idea of scope of practice has me a little concerned, because if you look at what scope of practice means, it is written vaguely for a reason. And so, although it may not be appropriate for a psychiatrist, or let's say a physical medicine specialist, to be looking at genitals, it's not necessarily outside the scope of practice. So I could, if I was allowed to at a hospital, even though I don't have oncological surgery training, my license allows me to do things in surgery, and I don't, because that's the scope of practice. I mean, I'll never get privileges to do it. So I'm having trouble understanding why this is so egregious. Would you agree, both of you, that if you have a very sensitive patient who has issues and maybe lack of trust of physicians, or like a lot of us do sometimes, would it be best, and I'm going to ask both of you, to see the patient at the facility for a quick look and see, then get into an ambulance with Kaiser and go to an urgent care, which is traumatic enough. And so I'm having trouble understanding this scope of practice that you, Mr. Chambers, keep saying he needs to stick within this narrow guideline. So I'm opening up to you all to help define, give me your definitions of the scope of practice and why this is so egregious.
So what I can tell you is what was testified to at the hearing. And Dr. Zinga Harrison stated that the practice at Casa Phoenix was, if an issue was emergent or needed care, they were to call an ambulance or send the person back to Kaiser or to urgent care. And in a case such as, let's say, patient DL, Dr. Chuang, who teaches at UCLA and works at a county facility in Los Angeles, he stated that a patient who's undergone sexual trauma, such as DL, should never have been placed in a position like he was placed in by Dr. Durrani. So that's the way I would answer it. I would answer it with regard to what was testified by the experts. And if you look at the testimony of Dr. Harrison, when she was looking at standard of care, she was so concerned that she reached out to many other people to confirm that her standard of care was what others considered it to be. This wasn't something that just two people came up with. This was something that she reached out to, Dr. Zinga Harrison reached out to others to make sure that she wasn't going out on a limb. As she testified, she believed that, she couldn't believe that this was actually a complaint against Dr. Durrani. And so the fact that this was occurring not once, not twice, but she found a third, which she then said she had a pattern. That was the term she used. So when we're talking about standard practice, I can only give you what those experts testified to.
Let me just interrupt you. I don't have the third case. It's not in the record. I have what's in the record.
And the
That's all I'm gonna go by.
And the record was what she testified to, and what she testified to was in her report.
Yeah, we don't go outside the record.
And exactly, and that's what I'm saying, it's in the record.
Okay. Do you have anything to add?
I do.
Briefly.
Okay. I'm frustrated, and Ms. Wright will understand my frustration with the notion that I'm hearing today that we're not just getting the opinion of Dr. Nzinga Harrison, we're getting her talking to 3 or 4 other doctors, and we don't know who those people are, let alone have any opportunity to find out what their positions are or what they think about all of this. This is replete with hearsay. The patients who are the primary players here were never brought to, they were never interviewed, they were never brought to testify. So it's a frustrating thing. On the question that you raised, Dr. Lewis, yes, there are 2 aspects of this scope of practice, I think. One is the notion of judgment, and when we read the APA guideline, it talks to us about judgment and the things that, as you say, are very ambiguous and should be kind of considered, things that we should take into consideration. And so I'm saying this is not a sexual issue. What we're here about is that very judgment. How should that have been resolved in this case, and how should we deal with that? The second issue with respect to scope of practice is competence, and I think that's raised in the APA issue. Dr. Durrani, as I say, is quadruple boarded. One of the boards in which he's is certified is psychosomatic medicine as well as addiction medicine, both of which have physical examination aspects to them, and he's required to do. So he is competent to do this. Now, the notion that this is a genital examination, I mean, we can look into the textbooks, into the urological textbooks, and talk about urological genital examinations. I don't think that that's what we were talking about in either case here.
Okay, thank you.
All right, anything? No?
I have a question about the facility itself. There seems to be, at least in my mind, a discrepancy of how free the patients are to come and go. So if, for whatever reason, something didn't come up when their last Kaiser exam, and it was discovered by Dr. Durrani, are the patients free to walk out and go to the Kaiser location and see their doctor?
There's 2 questions. I can answer it 2 ways. One is they are free to leave the facility. Whether they can get to the Kaiser by foot or that manner easily, I can't answer that. They do have the ability to transport, and they can transport people. But as far as a patient walking to the facility, I can't speak to the distance.
Okay, so if, once again, the patient is concerned because they found something on the bottom of their scrotum, I believe, is it realistic to say, I can't touch that, go to your doctor?
Is it realistic for the treating physician or
Is it-
psychiatrist there? to say that?
Correct.
Yeah, so first of all, with regard to DL, he knew he had a lump. He testified that he knew he had a lump on his genitalia. With regard to Dr. Harrison's testimony, they were expected to call and send the patient back to the institutional facility if there was a need.
Okay.
And so that's how the issue of insurance came up in costs in the testimony.
The response that I would give is, first of all, yes, it appears that the patient DL did say that he knew he had a lump. What he didn't know was that lump might be cancer. That's what he got in the middle of this examination with Dr. Durrani. That's what frightened him, and that's what led to what we see here. In terms of turning a patient loose to go see their own doctor, it doesn't happen at Casa Phoenix, doesn't happen at ANCA. In fact, the organization, the facility has responsibility for those patients, and so they have to make sure that they are safe. And depending upon mental acuity, they might have to call the police if the person wanders off in some way. So it's not a locked facility, but they are responsible for the welfare of the patients.
All right, 5-minute closing, Mr. Weinberg.
Thank you. I think that many of the things that I was going to address that were raised by counsel have come up in the questioning, but just a couple of things that I hope that the board will consider. I want to underline the notion that there's been talk about genital examinations. I would make the case that neither of these was a genital examination. One of them involved touching of the scrotum, but the notion that this was an actual genital examination for cancer, it was a triage examination to determine whether or not this patient should be sent back for precisely that kind of an examination and precisely some kind of a treatment. And also to try to reassure this patient who was very agitated and very frightened. I want to underline again that I think what the ALJ in this case, Diane Schneider, was saying was that there was nothing sexualized about this. She didn't imply that there was any sexual motivation that she had believed in any way. What she was saying was there has to be an appreciation for the notion of examinations that do involve, in general, sexually sensitive parts of the body. And I think Dr. Durrani knows that very well, and what he has been trying to say is that these two examinations were very brief and very special cases that had reasons to proceed with. However, it's a judgment call, and his expert witnesses, these two distinguished psychiatrists, have agreed with him that it was the appropriate thing to do. I understand that the board feels differently, and what we're saying is, to the extent that you feel that some education on these issues would be important to Dr. Durrani, he certainly is willing to do that. If you're concerned about how he deals with patients on these kinds of issues in the meantime, then some sort of a chaperone or a monitor to make sure that that was appropriately proceeding would be appropriate as well. And I would ask you that in your discussions, you do look at what these expert witnesses have said, because what they are saying is that this is a judgment issue, the exercise of clinical judgment, and whether it has been appropriately exercised in Dr. Durrani's case with respect to these two examinations. Thank you very much for your attention today. Appreciate this.
Thank you. Mr. Chambers.
At the beginning, we mentioned that this was about trust and judgment, and counsel just mentioned that these were judgment calls. Unfortunately, the judgment with regard to patient DL, when considering the history of that patient, was so far off the chart that it was just unconscionable. But what made the situation worse, and the ALJ noted with regard to the candor and dishonesty, was that there were moving targets with regard to the stories that were being presented. You just heard that DL was agitated and frightened. Who said that? Only one person. And that was at the hearing. That was the respondent. Respondent didn't say that when talking to Nzinga Harrison. DL didn't say that when making the written complaint, and DL didn't say that when being interviewed. These are misleading statements. It keeps changing. That's why the ALJ was so concerned about the ability to rehabilitate this doctor. It is about judgment. It's about sitting down and saying, you know what, I made a mistake. I made a mistake on this one, we can change it. But when the person does not even acknowledge, hey, I probably shouldn't be touching the genitalia with tissue or with glove or ungloved, as the patient said, when the patient has a history such as DL's, which is horrific, and that judgment is completely at odds with public safety. There's a statement earlier that the public has to be served out in San Joaquin County, the underserved and the underrepresented public. But with what type of judgment? A judgment that examined DL, who was not frightened, who was not scared. DL wasn't concerned about cancer. That was a red herring, that was a sham. It certainly wasn't in the records, and it didn't come up till late. The experts that were brought in for Dr. Durrani were not found credible by the ALJ. They may have said what Dr. Durrani wanted them to say, but they weren't persuasive. Dr. Durrani testified that he was triaging. He made it sound like he was overworked, overburdened, like he was Hawkeye Pierce at 4077, where he was keeping it all together. He was only there 4 to 5 hours a week. And if he, the director of the San Joaquin County Medical Health Facility, was so concerned by what was going on at Casa Phoenix, the idea that he didn't speak up is just ludicrous. His judgment is definitely in question here. And then it was the statements at hearing that really gave us pause, because he wasn't honest. And that's why the ALJ recommended revocation. Thank you for your time.
All right, thank you. Okay, that will conclude the oral arguments in this matter. The panel will now enter into closed session for its deliberation.
May I raise a question of procedure?
Yes?
I'm unfamiliar with this aspect, and I'm not sure whether we can perhaps resubmit or get a review of the question of the amicus brief from the health director of the county of San Joaquin. We were told that that was raising new facts. What it did was flesh out exactly what his job was there and what these people think of him, and this has come up over and over again here in council's argument today about what he's thought of out there in the county and what kind of work he does and how he does it. And I would like this panel to consider reviewing that amicus brief, because that'll give you the firsthand facts on that.
Okay, first of all, I don't know how is that categorized? If it's a character reference, how is that how is that an amicus brief?
How is it an
An
amicus brief?
brief is related to legal issues involved.
Well, and
It's not
policy
a
issues.
character reference, and that's what you're offering it to be submitted as. Is that correct?
Well, one of the things that the regulation says about amicus briefs is where there's a public interest aspect to this, and they were saying that he serves a very strong public interest where he works, and that's the basis on which they were submitting it.
Well, I don't have anything to do with or have knowledge of any brief submitted. That would be up to the medical board's counsel, I think, to have reviewed that. And I don't know was there a written request and decision that was submitted and it was denied. Well, then I think that's the answer. I don't think if the board sua sponte wants to reconsider that, then they can discuss that with their staff counsel and determine.
Thank you. I'll take it up with them.
Well, okay. Yes.
Something in the past session, the respondent would take 5 of the 15 minutes to give a statement of himself. I guess he's trying to use it all up.
Right. Well, I asked counsel at the beginning if he wanted to reserve time for him to speak, and he said no. So I'm not going to.
I'm sorry, I maybe misunderstood. You asked me,
I did.
and what was the question?
Do you want to reserve any time for respondent to speak directly to the panel members? And your answer was no.
Ah. If that would be helpful, I would like to retract that, if I may.
Well, look, the procedures are by regulation, the time limits are by regulation. You've used your time. Mr. Chambers has not used his time, but that's, the regulations set the time limits. That's why I asked you at the beginning if you wanted to reserve time, and I would have gladly done that, but no,
I'm
this is
just-
not a free-for-all.
I'm
So,
just saying I'm thanking the
okay, no, again, this is not a free-for-all.
Understood.
Thank you. All right, that is the hearing in the matter. The record's closed and the matter is submitted.